All right. Good morning. It is 9 a.m. on July 15th. This is a special docket held by the Oil Conservation Division to hear particular cases that were either continued from other dockets or require special assistance of technical team. We also had some cases that were contested that I understand at the last minute last night became uncontested. We need to talk about that when it comes to the court reporter and charges that the division incurs. We have a cutoff time of 3 p.m. the day before to inform Veritex that we don't need a court reporter. If these were the only cases on the docket, we would have the pre-hearing order that says these will be heard on the 7th of August, which is the next regular hearing by affidavit docket. But because we had other cases today, we left them on the docket. But in the future, if you're going to, if you have a contested case and the objection is withdrawn, we need to know by 3 p.m. the day before so we can cancel the court reporter and not have an unnecessary charge to the taxpayers of New Mexico. If that doesn't happen and we do convene, then the party who is going to go forward will have to pay for the court reporter if they want to go forward that day. Okay, that being said, let's call our first case, and we're going to move this case, we're going to move one case to the end of our docket since we have basically all hearing by affidavits today. We're going to move the AGI case, which is the Lee Midstream, number 7 on our docket. We're going to move that to number 11 on our docket because I anticipate that one taking the most time today. All right, let us begin with cases 1 and 2 on our docket. That is 25234 and 35. These are Mewbourne oil cases. Enter your appearance, please.
Good morning, Mr. Examiner. Dana Hardy with Hardy McLean on behalf of Mewbourne Oil Company.
Good morning, Mr. Hearing Examiner. Darren Savage with Aberdeen Shell on behalf of Devon Energy.
I wonder if we have anyone here from ConocoPhillips or COG or Civitas. Miss Hardy.
Civitas, our attorney just in the last day left the company. So I'm here. I'm a landman for Civitas. We have no objection to anything.
Okay,
here, I know that.
Can you state and spell your name for the record, please?
Sure, it's Chad Matney, ChadMatney.
Thank you, sir. Ms. Hardy, do you know who was representing ConocoPhillips and Concho and COG?
I believe it was their in-house attorneys, Ms. Ryan and Ms. Hatley. I know that they don't object to these cases going forward. Okay, great.
Why don't you proceed? I think if I'm not mistaken, you came to hearing a week or two ago. There were additional exhibits and evidence required. You've submitted them by the deadline, and now we basically turn to Mr. McClure once we admit these. So are you asking for the admission of these documents?
Yes, I am. Mr. McClure had requested an updated version of Exhibit A3 to provide additional breakdown of the ownership interest, and we did provide that. So I would ask that those exhibits be admitted.
Okay, great. And did you admit did you submit a amended exhibit packet with a cover letter?
We did, yes.
Perfect, great. Mr. McClure, did you have time to, so those are admitted without objection. Mr. McClure, did you have a chance to review?
Yes, I did, Mr. Hearing Examiner.
And may this case be taken under advisement?
Yes, it may.
Okay, great. And what about the next case, 25235, same?
That is correct, Mr. Hearing Examiner, if you're asking me.
I am, thank you. Okay, Ms. Hardy, thank you very much.
Thank you.
Now we're moving on to number 3 on the docket, Mewbourne Oil 25288. Enter your appearance, please.
Good morning, Mr. Hearing Examiner. Paula Vance with the Santa Fe office of Holland and Hart on behalf of the applicant, Mewbourne Oil Company. And we are here today. I filed a revised hearing packet.
I was waiting for from someone from Bradford Sayer
Sure, yeah.
to enter an appearance. Unless they're not with us either.
I didn't see
You didn't see
either.
them? Okay.
No, not.
Please
at the
proceed.
time. So in this case, we presented last week and we filed a revised hearing packet that reflects the breakdown of the voluntary interests. And I did file that before 5 p.m. on Friday.
And which exhibit was amended?
I believe it would be exhibit C3, but let me just look real
Okay.
quick. I'm sorry, C2.
C2.
Mhm.
And did you file an amended packet with a cover letter?
Yes.
Okay, perfect. So C2 is admitted as amended without objection. Mr. McClure, any questions, or can we take this case under advisement?
No, Mr. Hearing Examiner, I have no questions and we can take this case under advisement.
All right, perfect. Thank you, sir. Thank you, Ms. Vance. Moving to number 4 on the docket, 25409 Matador Production.
Good morning, Mr. Hearing Examiner Paula Vance with the Santa Fe office of Holland and Hart on behalf of the applicant Matador Production Company.
Okay.
And good morning, Mr. Hearing Examiner Yaritza Pena with Module Sperling on behalf of Avant Operating 2 LLC and Dogwood Exploration LLC.
I didn't see your client listed here under other parties. When did you enter an appearance?
We entered an appearance last week on Wednesday afternoon before this case went to hearing. I'm sorry, Thursday morning, actually.
Okay. Brad, did you get an entry of appearance from Ms. Pena? From Avant?
I did. I failed to add it to
Oh, that's
this
okay. I just
spreadsheet.
wanted to see if you got it.
I did.
Okay, thank you. And there's no objection?
No objection.
No, okay. So last week, what happened, Ms. Vance?
So we presented the case at a earlier docket, and we were following up. So we did file a revised hearing packet so that the CPAC identifies the interval within the Pennsylvania formation that Mr. McClure requested we include. We also updated the pooling exhibit, which would be exhibit C4, to reflect Ms. Pena's client's interest in that it is being pooled.
Thank you. And you submitted an amended exhibit packet with cover letter?
Yes.
Okay. All right, so that's admitted into evidence without objection. Mr. McClure, case number 4, may we take it under advisement?
Mr. Hearing Examiner, yes, we can.
Okay, thank you, sir.
I have just one really
Go
quick
ahead. question
for clarification, just to provide to clients. What is the cost of the court reporter?
Let me ask the court reporter. He's sitting next to me. Oh, no idea? Okay. Well, he doesn't know. Miss Chance, do you happen to know what it costs to have a court reporter come up to Santa Fe?
On average, our transcripts are about $3,000 to $4,000 per hearing.
Per hearing?
Yes.
And do you know if they would charge that just if they came up for nothing, let's say, and they were sent back? Do you know what the charge would be for coming up and doing nothing and going back?
There's a cancellation fee. I can't remember what that is. Maybe 400. I'm not sure. I have to look at the contract.
Will you do that and let me know so I can advise the
Sure.
parties? Thank you. We'll get you an answer. Thank you.
Thank you.
All right, now, let's see. Next, we have Avant operating case numbers 25347, 25348, and I believe we're hearing these for the first time by affidavit.
Yes, that's correct. Yaritza Pena with Module Sperling on behalf of Avant Operating 2 LLC.
And Mr. Examiner, Dana Hardy with Hardy McLean on behalf of Permian Resources Operating. And we have no objection to these cases proceeding by affidavit.
Thank you.
Good morning, Mr. Hearing Examiner Paula Vance with the Santa Fe office of Holland and Hart on behalf of Matador Production Company, and we don't have any objection. We're just preserving rights.
I'm waiting for one more party.
Again, Chad Matney with Civitas, no objection.
I see. Okay, thank you. I forgot your last name. I was just say Chad. Who was representing Civitas?
Michael Rodriguez was our attorney.
I didn't know. Thank you very much.
Yep.
Okay. Ms. Pena,
Yes, I can present these consolidated.
go right ahead.
Thank you. So we filed our amended exhibit packet pursuant to the pre-hearing order last week on July 8th, 2025.
Ms. Pena, I saw an exhibit pack, but I didn't see it labeled as amended, nor did it have a cover letter. Am I missing something?
I believe we didn't submit a cover letter because we were at that point still proceeding under the pre-hearing order. So we were going to go to a contested hearing. But we could resubmit with a cover letter and say that it's the amended hearing packet.
Yes,
the
and
division.
please, in the
Okay.
future, anytime you have to, because I saw the one from May 1st, and then I saw the one from July 9th. And I thought, this has to be amended, but it didn't say amended anywhere on it, nor did it have a cover letter. So I wasn't sure what may have changed over that time period.
Okay.
And it just helps the technical reviewers know what's changed as well.
Yes, absolutely. We can definitely do that right
Thank
after
you.
this hearing.
So it was Ms. Vance's client that withdrew her objection last,
Yes.
which is
Yes.
how you're able to go by affidavit now. Okay,
That's
by all
correct.
means. Go ahead.
Thank you.
Mhm.
In case 25347, Avant things in order, approving a non-standard 560 acre, more or less, Wolf Camp horizontal spacing unit, pulling all the interest in the east half of section 22, the northeast quarter, and the north half, southeast quarter of section 27, township 20 south, range 32 east in Lee County, New Mexico, in the Salt Lake Wolf Camp pool. And in case 25348, Avon seeks an order approving also a non-standard 560 acre, more or less, Bone Spring horizontal spacing unit in the Salt Lake Bone Spring pool. The amended packet that we did file last week on July 8th includes the checklist, and exhibits under tab A contain the self-affirmed declaration of Tiffany Sarantinos, the landman for Avant, who has previously testified before the division, and her credentials have been accepted. Following her affidavit are the standard land exhibits. Exhibits under tab B contain the self-affirmed declaration of John Harper, the geologist for Avant, who has also previously testified before the division. And behind his affidavit are the standard geology exhibits. Exhibit C contains the self-affirmed declaration of Shane Kelly, the vice president of engineering for Avant, who has also previously testified before the division. And exhibits under tab D contain the notice exhibits, including my self-affirmed declaration, the sample notice letter for the mailing list showing that we sent notice to all interested parties on April 14th, 2025, and a subsequent letter on May 8th, 2025. And out of an abundance of caution, the two affidavits of publication from the Hobbs News Sun showing that we timely published on April 16th, 2025, and on May 11th, 2025. With that, I would ask that the exhibits in cases 25347 and 25348 be admitted into the record, and that the cases be taken under advisement. And I believe all of our witnesses are available for questions.
All right. Okay, without objection, the amended exhibit packet filed on July 9th, even though it's not titled that way, is admitted into evidence. Mr. McClure, do you have any questions for any of the witnesses?
Mr. Hearing Examiner, I am going to have questions for the landman.
Okay, and Ms. Pena, your landman?
Ms. Sarantinos, Tiffany Sarantinos.
Okay, let's get her on the screen, get her sworn in. Okay, would you raise your right hand, Ms. Sarantinos? Do you swear or affirm under penalty of perjury that the testimony you're about to give is truth, the whole truth, nothing but truth?
I do.
Good. You can put your hand down. Would you spell your name for the court reporter, please?
It's Tiffany, Tiffany, Sarantinos, Sarantinos.
Have you been qualified as an expert by this division?
Yes, sir.
In what field?
Petroleum landman.
Perfect. Thank you. Mr. McClure?
Thank you, Mr. Hearing Examiner. Ms. Sarantinos,
Yes.
I'm looking at the lease track map found on page 33 of 126. This is the exhibit A3. It appears that the south half of the southeast quarter of section 27 is not included within the proposed unit. Can you provide me with the status of that particular track?
Yeah, it is not part of our unit.
I understand that. Can you provide me with the status of what's going on with that track?
I'm not sure. I think it is not. Let me look really fast. I do believe it is part of another pooled unit. And there is DAs out here, and this is already an approved DA, which is the 560 acres that is included in our unit. So we weren't able to pull in any additional acres.
Okay, I guess maybe I didn't understand what you were getting at there. Are you saying that Avant already has the south half of southeast quarter in another proposed unit?
We do not, but it's a BLM. It's part of the potash, so it's the DAs, the drill islands, and the development areas have already been predefined.
Okay, so this is a part of a drilling area for the potash then, is that correct?
That is correct, yes.
And it includes the south half of the southeast quarter of section 27 and nothing else in the east half of section 27?
That's correct. The southeast or the south half of the southeast is not included in our unit or the DA island or development area.
I'm sorry, say that one more time. I don't know if you misspoke. You say that the south half of the southeast quarter is included in the developmental area for.
It is not included.
Okay, so then the rest of your unit, is that part of a drilling area in the potash for the BLM?
Yes.
Okay, but that drilling area then does not include the south half of the southeast quarter of section 27, and that's the reason that Avant is not proposing to include it in this unit.
Correct.
And are you aware of which operator has the rights to drill in that south half of the southeast quarter of section 27?
Not off the top of my head, to be honest. But it's not us.
I'm just scrolling down to your geology exhibit. Look real fast. Okay, Miss Saratinos, if I can draw your attention to your summary of contacts, page 78 of 126, Exhibit A6.
Let me get there real fast.
Specifically, I'm looking at the first case, 25347.
Mm-hmm.
My speculation is you may have forgot to include a slide here because in the other exhibit packet, you have an additional slide. My question to you is, do you have included here the details in regards to your contacts other than Matador?
It looks like, yeah, it should have the summary of contacts included in both 25348 and 25347.
Okay, so in the exhibit packet, That's for 25348. Are you
Mhm.
familiar with that extra slide that I'm referring to that's not included in the exhibit packet for 25347?
I am.
Okay, and does it also apply to case 25347?
It does. Yep.
Okay, so if I were to ask you to include and to resubmit this exhibit packet and include that additional slide for case 25347, do you understand what I'm asking for?
Yes, it would be. Yep. Yep. We can certainly do that.
Okay, in the application for both of these cases, it appears that Avant is asking for approval of a non-standard paration unit. Is that correct?
That is correct.
Okay, I guess why does Avant believe that the proposed HSU is non-standard?
For this unit in particular.
Yes, ma'am.
I think in this one in particular, the surface space is very, very limited with the drill islands out here. So we wanted to be able to minimize the surface use and use a single battery site out here for both of the units here, the Wolf Camp and the Bone Spring. So
Now let me rephrase my question. With consideration to both of these proposed units having two wells drilled down the center line of the east half, why does Avant believe that this proposed unit is non-standard?
well, we do have more wells than just 2 wells.
To provide a little bit more context.
Yeah.
I'm trying to figure out if I'm missing something because from the review, it appears to be a standard spacing unit. And I'm wondering why Avant believes that it's non-standard and why they're requesting that approval.
I don't know. Maybe I could have Yari drop in here and help.
I'm sorry, who was that?
If
Is that
Yari
your
can
guys'
help out here,
geologist? Is that your
or
guys'
the
geologist?
council.
Or?
I just want to make sure I'm understanding the question. Yeah.
And Mr. McClure.
Hold on. Let's stop for a minute. Ms. Pena.
Yes. I believe, Mr. McClure, maybe this question would be better suited for a reservoir engineer, Shane Kelly, who's also on the line, who could explain a little bit more about why Avant is seeking a non-standard spacing unit.
Okay, so when Mr. McClure's finished with his questions for Ms. Sarantinos, we'll swear in the reservoir engineer and deal with that.
Mr. Hearing Examiner, I am finished with my questioning of Ms. Sarantinos now.
Very good. Ms. Sarantinos. Well, Ms. Pena, are there any follow-up questions to Ms. Sarantinos?
I do have a follow-up question that can maybe help explain to Mr. McClure about about notice to the offset operators for the non-standard spacing unit. Ms. Sarantinos, do you remember your exhibit A3, the notice to the offset operators? It's on page 35 of 126.
I do. Yes.
And Mr. McClure was asking you about the south half of the southeast quarter.
Yes.
And he asked you about what operator is in charge of that section of the unit.
Yes. Sorry, let me
Is this
get back
exhibit
in here.
helpful to answer that question?
Yes. Thank you. Sorry. Get there.
Ms. Pena, can you direct us to a page number in the exhibit? I don't remember where that was.
It is page 35 of 126.
And it looks like it is XTO. Thank you, Yari.
No problem. And Mr. McClure, we can submit an amended exhibit packet after the submitting that additional slide that we inadvertently left off.
Yeah, Ms. Pena, I think there's gonna be a few things to amend in the second revised exhibit packet.
Yes.
Which will require additional review from Mr. McClure. So we'll have to figure out if we can get this on the August 7th docket, but let's get your reservoir engineer on the screen.
Mr. Shane Kelly.
Mr. Kelly, would you raise your right hand for me? Do you swear or affirm under penalty of perjury that the testimony you're about to give is the truth, the whole truth, nothing but truth?
I do.
Great. You can put your hand down, sir. Would you spell your name, please?
Shane, Shane. Kelly, Kelly.
And I know that you have been qualified as an expert because I've seen you before. So, Mr.
Yeah.
McClure? Mr. McClure?
Thank you, Mr. Hearing Examiner. Mr. Kelly, did you hear my questioning of Ms. Saratinos?
Yeah, you were asking why this unit is non-standard. Is that correct?
Yeah, let me, I guess, rephrase my question. Why does Avant believe that the proposed unit is non-standard?
Yeah, so we have we're planning on one CTB here again due to the surface restraints in the area being potash. Obviously, there's some limited surface, so we want to do one CTB. Also, the 302, 502, and 602 are on that quarter line. And so that would ultimately make that unit non-standard, which allows us to produce on that quarter line. And we feel like that's the best way to preserve all the rights in the acreage and produce the most efficiently out of this piece.
Okay, thank you, Mr. Kelly. And just, I guess, to forewarn you, if the division rejects or denies Avant's approval for the NSP, you do not need an NSP to propose to produce this unit as you have these wells proposed here.
Okay.
Do you understand
guess,
what I'm referring to?
I believe so. I don't believe we've had that in the past every time it has been approved. So I think that would be the first time for us. Especially when going into one CTB to protect everybody's rights.
Well, Mr. Kelly, if the proposed unit is standard, then it's not necessary for the division to grant approval for non-standard HSU, which as proposed here, it's a standard HSU.
Okay.
Mr. Hearing Examiner, I don't have any more questions, but I do have some guidance that I would like to provide to Ms. Pena.
Okay, does the guidance include the exhibits that you want amended or the additional evidence you need?
Yes, that is correct, Mr. Hearing Examiner.
Go right ahead, Mr. McClure.
Okay, Ms. Pena.
Yes.
As you already heard, the slide for summary of contact, specifically for case 25347, do you understand what I'm referring to if I ask for you to amend that exhibit to include the missing slide?
Yes, I do.
In addition to that, on the CPAC for each of the cases, if I can draw your attention to page 3 of 126 in case 25347.
Okay.
Where it references down there that there are no proxy tracks, or you say NA, there in fact is proxy tracks in this particular instance. Do you understand where I'm looking at, how my conversation had been with Ms. Saratinos and Mr. Kelly?
Yes, I think I do follow.
Okay. Are you in agreement that the proposed unit is in fact standard?
I believe, I mean, based the way we drafted our application and the reasonings that Mr. Kelly explained why Avant would request an NSU, I'm not, if the division isn't, I guess I'm just not following if the division would like us to amend the checklist to include proximity truck wells instead of requesting an NSU. Is that?
Well, in order to make your CPAC accurate, that would be the way to do it.
Okay.
Having said that, the division will end up having to reject because it's in the application, we'll be rejecting the NSP anyway, regardless of how we change the CPAC. But to make the CPAC more accurate, we would ideally say that the HSU is in fact standard and include the proxy track and then the defining wells. I believe each case actually has 2 different wells that can be used as defining wells.
Okay, I understand.
Okay. And Miss Pena, that's everything I have. Mr. Hearing Examiner, yeah, that's everything I have for these 2 cases.
Okay, thank you, Ms. McClure. So Ms. Pena, August 7th. Freya, how big is the August 7th docket?
Let me check one moment.
We have a special docket on the 29th of July, Ms. Pena, but that's already too big to put this case on there. Mr. McClure, you're requesting revised exhibits for both cases or just 47?
Mr. Hearing Examiner, I would like to request it for both cases.
Okay, I just wanted to make sure. Thank you.
There's 63 cases on the August 7th docket right now.
All right. Let's put these 2 cases toward the beginning of that docket, which means we may have to bump some other cases up here. Ms. Pena, I don't know if you have anything else in that docket, but we have a limit of 60 that we can take on a hearing by affidavit docket. Okay, so Ms. Pena, let's see, to give the technical reviewer time to review, should we say a week from today? Does that give you enough time?
Yes, that's plenty. Thank you.
All right, you're welcome. So that's the 22nd, I believe, of July, close of business. And please put a cover letter to explain the changes. Okay. Is there anything else, Ms. Pena?
Nothing further. Thank you.
We're off the record in these 2 cases. Thank you. The Leah Midstream we're going to hear last. Let's go to Matador Production. These were contested until yesterday at almost 5 p.m. These are case numbers 25388, 25390, 91, and 93. Entry of appearance, please.
Good morning, Mr. Hearing Examiner Paula Vance with the Santa Fe office of Holland and Hart on behalf of the applicant, MRC Permian Company, Matador Production Company.
And good morning, Mr. Examiner. Dana Hardy with Hardy McLean on behalf of BTA Oil Producers LLC.
And you withdrew your objection?
BTA had not objected. We are monitoring these cases.
Yes, good morning, Mr. Examiner. Scott Morgan with Cabin and Morgan on behalf of Wyotex et al. And yes, I think we did come to an agreement to withdraw our objection yesterday with Ms. Vance and Matador, and so we did file those withdrawals.
Okay, and you say you filed them. How did you file them?
My clients do not have OGRID numbers, and so we have typically in the past emailed them over to the NMOCD, but we are happy to make changes to that process as requested.
Okay, and let's see, yesterday, Ms. Chance was out. Did you send those to Ms. Corral?
We sent them to Ms. Chance, but I believe that actually, and I appreciate Ms. Vance doing this, forwarded them on otherwise to ensure that the correct parties had them.
Okay, thank you. Okay, so you have no objections to anything going forward, is that correct?
We do not. We know that this is set for the August 7th hearing to move forward by affidavit. We would still request that remain on that August 7th docket. Simply to give us just that additional amount of time. The OCD has done a phenomenal job of moving things a lot more quickly than maybe we have seen in the past and getting those orders out. And while we're happy to withdraw our objection, we still do need a little bit of time to finalize agreements.
All right, let's finish with the entries of appearance, and then we can talk about this. Who else do we have? Anyone that you know of, Ms. Vance? No, just two parties, basically.
Just two parties,
Okay,
that's correct.
so your argument in proceeding today instead of waiting till August 7th?
So we filed these applications at the beginning of May, and I understand Mr. Morgan and I, we talked about this. We would very much like to move forward today. To your point, we've got a lot of cases already on the August docket. There's no reason to delay these. Again, they were filed in May, and we would like to move forward. We have our witnesses available, and we're ready to go. So we would ask to move forward today.
Mr. Morgan, do you have a good reason why we should delay this until August 7th?
I think just briefly, part of my client's willingness to withdraw the objection was in the hopes that we would have that additional about 3 weeks to finalize these agreements before they are actually heard.
Well, Mr. Morgan, I give you the opportunity to reinstate your objection, or else we're going to go forward today.
If we were to reinstate our objection, we would move forward today with with a contested hearing. Is that correct?
Correct.
Okay. Yeah, in that case, since my witnesses are not available today, because they were assuming that the August 7th hearing date would stay in place on the uncontested hearing, then we won't be able to reinstate our objections today.
I'm confused. Would you?
Yep. I apologize. My witnesses are not available today to move forward with a contested hearing today. That based on the assumption that these would still be heard uncontested on August 7th. And so, yeah, we wouldn't be able to move forward with an uncontested hearing, or excuse me, with a contested hearing today. And so for that specific reason, I would not be able to reinstate my objections today and move forward.
When you say you would not be able to reinstate your objection, you've withdrawn your objection. So at this point, there is no objection for them to go forward with the hearing by affidavit.
Correct.
Right. So then what you're saying is you are not reinstating your objection so that we can have the contested hearing at a future date. You're fine with them going forward by affidavit today.
If we refile our objection and the contested hearing were to be held on a future date, then yes, we would reinstate our objection.
Ms. Vance?
Again, we filed these in May. The August docket is already full. You know,
As I heard this argument before, what I need is something based in the rules. If there's something in the rule that says that they can't reinstate their objection, I'd like to know what it is.
I don't know anything. I would have to look to see, but there's nothing that I can think of or have read that says that would prevent them from reinstating their objection.
Right. Right.
But if they aren't going to object, there shouldn't be a delay in these
Agreed.
proceedings moving forward.
So Mr. Morgan, if you, so what if we do this? Why don't we give the parties 5 or 10 minutes for you to discuss this? You and Ms. Vance, I think, should discuss this. If you think you can resolve any differences and maintain your non-objection, because right now we have no objection from you. You have withdrawn it officially. I gave you the option to reinstate your objection or to file a new objection based on what you just told me about, you know, you thought that this was going to be August 7th and you wanted to finalize negotiations, et cetera, et cetera. So we either can go forward today without an objection and then we're done, or you can tell me you object now and we can set this, because it won't be on the August 7th docket. We'll have to find a new special docket for these cases. So do you want some time to talk to Ms. Vance, or do you know how you want to proceed?
I think if we could have 5 minutes, I think I may have a solution that I can discuss with her briefly.
Excellent,
I think
excellent.
Yeah.
I thought so. Okay, so it's let's say it's 9:40 now. We'll come back on the record at 9:45. Thank you.
Thank you.
We're ready for you, Ms. Vance. All right, we're back on the record. It is 9:46 a.m. I am reviewing the pre-hearing order that was issued in this case a while ago, and it does say in paragraph 2, if objections to a hearing by affidavit are subsequently withdrawn, the cases will proceed by affidavit on August 7, 2025. So I understand, Mr. Morgan, why you thought the pre-hearing order would control the hearing by affidavit date. Did you resolve this issue with Ms. Vance?
I think that we have. Ms. Vance, I just sent you a follow-up email.
I just saw that.
Ms. Vance?
Yes, we have an agreement, but I think we'll need to just make sure that the order is specific for his clients, some verbiage that would allow them 60 days to elect under the pooling order, and then 30 days after election to pay. So that would be something we can provide a revised hearing packet to include that language specific for his clients, and request that the division include that in the order.
Well, when you say request the division to include that in the order, Mr. McClure, does the division normally do that?
In some instances where a party has struck a deal, then yes, we have done that in the past.
Thank you, Mr. McClure. So, Ms. Vance, if we hear the case today, if it's 4 cases today, it sounds like we're going to have to come back on the record at a future date to review whatever exhibit that you have to file.
I can be here on 7/29 if that is helpful.
7/29 is already full. We can hear these cases today and then take them first on the August 7 docket.
I will take that if that's the best we can do.
Well, otherwise we can just hear them on August 7, the way the pre-hearing order has instructed.
I get the feeling I'm going to be presenting a lot of cases that day. So if I can knock out some today, I think that would be my preference.
All right, why don't you go ahead then? So, Mr. Morgan, you do not object to Ms. Vance proceeding by affidavit today, is that correct?
No objection at all. Thank you.
Very good. Thank you, sir. Ms. Vance?
Yes, thank you. So in these 4 cases, Matador is seeking to pool the uncommitted interests in acreage that is all in Township 15 South, Range 36 East, and that's in Lee County. The pool that we are dealing with here is it's a part of the Pennsylvania formation, and that pool is the Dean Permo Upper Penn, and the pool code is 16720. Okay, sorry, I got a quick email from my client and just wanted to take a look at that. So in case number 25388, this involves a 480 acre, more or less, horizontal well spacing unit in the Pennsylvania formation, and that's going to be underlying the west half of sections 11, 14, and 23. And Matador seeks to initially dedicate this spacing unit to the Ed Drake FedCom 241H well. Then in case number 25390, Matador is pulling the uncommitted interest in a 480 acre, more or less, horizontal well spacing unit, again in the Pennsylvania formation, underlying the east half of the west half of sections 11, 14, and 23, and initially dedicating that to the Ed Drake FedCom 242H well. Case number 25390, again, a 480 acre, more or less, horizontal well spacing unit in the Pennsylvania formation, and that is underlying the west half of the east half of sections 11, 14, and 23, and initially dedicating that to the Ed Drake FedCom 243H well. And then lastly, in case number 25393, Matador is seeking to pool the uncommitted interest in a 480 acre, more or less, horizontal well spacing unit in the Pennsylvania formation, underlying the east half of sections 11, 14, and 23, and initially dedicate that to the Ed Drake FedCom 244H well. In each of the hearing packets, we have included the compulsory pooling checklist. I did file revised hearing packets make sure that we had the correct interval, just like the Steve Rochelle cases. On the CPACs, we also included a copy of the application and then the self-affirmed statements of our landman, Addison Costley, who has previously testified, and his credentials have been accepted as a matter of record, as well as Mr. Joshua Burris, who is the geologist and has previously testified as well. In each of both for the land and geology, we have included all the standard sub-exhibits. And then following that is a self-affirmed statement from myself with a sample copy of the letter notice that went out that was timely on May 16th, 2025. And then last is the affidavit of notice of publication that was timely published on May 18th, 2025. And unless there are any questions, I would ask that the exhibits and sub-exhibits be admitted into the record and that these cases be taken under advisement at this time. Yeah, that's all I have.
Okay, without objection, thank you. Mr. McClure, any questions?
Mr. Hearing Examiner, I will have questions for the landman.
Okay, Ms. Vance, would you call your landman?
Yes, I know he is on here. He's got his camera up and he's ready to answer.
And I recognize Mr. Costley. Please raise your right hand. Do you swear or affirm under penalty of perjury that the testimony you're about to give is the truth, the whole truth, and nothing but the truth?
Yes, I do.
All right, thank you, sir. You can put your hand down. Would you spell your name?
Yes, Addison Costley, Addison, Costley, Costley.
Thank you, sir. And you have previously been recognized as an expert in what field before this division?
Petroleum land management.
All right, thank you. Mr. McClure?
Thank you, Mr. Hearing Examiner. Mr. Costley,
Yes, sir.
what is the vertical extent that Matador is requesting the division to force pull in these 4 cases?
Little confused on the question. Do you mean, I guess, the vertical depth or the depth in which we seek to force in the pin shale formation? I guess I'm a little
Let me rephrase my question. I'm not asking for specific vertical depths. What formation or subset of a formation is Matador asking to the division to force pull in these cases?
Oh, okay, yeah. We are seeking to force pull the Cisco and the Canyon formations. I guess sub-formations within the Pennsylvania.
Okay, thank you, Mr. Costley. Mr. Hearing Examiner, I have no more questions for any of these 4 cases, but I do have some requests for Ms. Vance.
Go right ahead.
Thank you, Mr. Hearing Examiner. Ms. Vance, based upon what the landman just testified to, on the CPAC, you know where I'm referring to when I say the vertical limit for each of these?
Yes, and we did. Yes, I do.
Okay. And are you thinking that you might have submitted some at some point that had that vertical limit in there?
Yes, I thought that the revised hearing packets that we filed, and now that I'm looking at them, for some reason, I did update these. And it does not look like it has the vertical extent in there, and I have no idea why. Because I added what we did to the Steve Rochelle. I'll have to follow up. Yes, I can update that. I'm not sure why that is not in there.
Okay. And
I did revise those, and for some reason what got filed is not the revised version. So that's an easy fix. I can take care of that as soon as I'm back at the office.
okay, Ms. Vance, and you think that's the only change that didn't make it in here then? Does that sound correct to you?
Yes, that because the other change that we discussed that we also included across all 4 of these cases was on the exhibit D3 that we did that also highlights, or it shows the top of the strawn, which you requested in the other case. So I'm more than happy to do that. It will not take me that long. I do have one other thing to add unless the technical examiner has additional questions.
I do, Ms. Vance. So you do understand what I'm asking for then in regards to the vertical extent, is that correct?
I do.
Okay. In addition to that, you're familiar with the practice of putting the special provisions / stipulations in the CPAC?
I
And where that's
do.
that located?
I do, but I actually was going to get to that because I had some further follow-up email with Mr. Morgan, and we have actually agreed to just have a letter agreement between the parties, so that would not require any action on the division's part to change anything. So I think the only thing that I would need to do, unless there's something additional, would just be to update the CPACs with the vertical extent.
Yeah, Mr. Hearing Examiner, I have nothing further for any of these 4 cases, with the understanding they're going to update the CPAC to have the vertical limit in each.
Okay, thank you. All right, so Ms. Vance, would you continue these cases to the August 7 docket? And Ms. Chance, will you put them first on our docket?
Yes.
Would it, Mr. Hearing Examiner, if I could, while my colleague, Mr. Felderwerk were presenting his case, if I were able to make that change and refile while I'm sitting here, could we just go at the end of the docket? That way it wouldn't waste any additional time of the division.
Mr. McClure?
Mr. Hearing
McClure-
Examiner, if that works for you, then I should be able to review it while the division's hearing the AGI case, if that's what Ms. Vance is asking.
All right. Okay, thank you, Mr. McClure. That's what we'll do. So you go ahead and we'll hear our last case now. This is Leah Midstream.
Thank you.
Yes, case number 25413. And your appearance, please. Do we have any other parties?
Morning, Ari Baronoff, the State Land Office, on behalf of the Commissioner of Public Lands and Stephen.
Mr. Burnett, I don't see you on the screen.
I'm here at the meeting room. Here at the meeting room, the mic is supposed to be situated somewhere else.
At the table would be great.
Okay, bye.
There's a button on the microphone on the right. When you press it, it'll light up green. And would you enter your appearance again using the microphone?
Of course, Ari Baronoff from the New Mexico State Land Office. I'm here on behalf of the Commissioner of Public Lands and the State Land Office.
Okay, I think I saw your entry of appearance. And did you file a pre-hearing statement?
We did.
When?
On Thursday.
Thursday.
Mm-hmm.
Did you have any witnesses?
At this point, Mr. Examiner, our main intention is to make clear to you, to the tribunal, that we have serious reservations about this application. We learned about this application around 3 weeks ago. June 20th is the date of the notice. The land office received it on the 23rd, excuse me, and for several weeks has been trying to get information and get an agreement with the applicant, and so far that's been unsuccessful. So the focus of our efforts has been there. I did list 2 witnesses in the statement. Our preference, though, would be that this matter be continued because we don't think that there's been adequate notice to us as an affected landowner to develop our case. We would also like to pursue the possibility of a negotiated resolution with the applicant, but we're just not there yet.
All right, thank you. Okay, are there any other parties that you know of, Mr. Felderwerk?
No, sir.
All right. Please proceed.
Mr. Examiner, the applicant seeks authorization to inject acid gas from its Lee Midstream Treating Facility or disposal into its proposed White Russian AGI #1 well, which if you take a look at what we filed, if I may bring it up on the screen. Give me 1 second. Believe I should be sharing now up on the screen. Great. Okay. So this is the location of the AGI, White Russian AGI #1 in section 17, township 19 south, 35 east down there in Lee County. You'll see it has a surface location and it's a deviated well to get to a bottom hole location on section 17. Lee Midstream currently owns the surface where the surface hole is located, and they are acquiring the acreage where the bottom hole location will be located. The proposed injection zone is the Siluro-Devonian Formation, which is comprised of the Devonian, Riston, and Fusselman formations. Pretty deep. You're at about 14,000 to 16,000 feet. They seek approval to inject 12 million standard cubic feet of treated acid gas per day with an allowable operating pressure of about 4593 PSIG. And nice thing is at full capacity, this well will be able to permanently sequester approximately 487 tons of carbon dioxide and approximately 162 tons of hydrogen sulfide daily. Now, we have submitted in our packet evidence noting the critical and immediate need for this acid gas disposal in this part of Lee County. If you take a look at what we marked as Exhibit B2, it contains a list of affected wells on state, federal, and fee lands. There's over 100 wells that have been drilled that are awaiting completion due to the lack of reliable acid gas takeaway and disposing capacity. So we're trying to help the state land office here by getting production occurring on their lands. So due to the immediate need for this, we respectfully request that you consider expediting this application. We have in our hearing packet.
Mr. Featherweight, before you continue with your hearing packet, would you respond to the argument Mr. Burnoff made?
Certainly. They received notice just like every other landowner did out here. The state land office did.
And this was sent when?
This was sent by letter dated June 20th. In addition to that, if I need to submit the email, I would be surprised if I do. The C-108 application was previously sent or also sent to Ms. Allison Marks in late June so that they could actually have discussions on the White Russian, which Ms. Allison characterized as good discussions. So it's not like we have not been in touch with the state land office. So I don't see any reason to postpone this hearing here today. Now, you mentioned their entry of appearance filed on Thursday, which was after we filed our pre-hearing statement in a timely manner on Tuesday, July the 8th. So they're a little bit tardy in coming into this. But I can tell you that, and the client is committed to continue to work with the state land office to address their issues. So with that said, we want to move forward today. There's no reason why we should not move forward today. And we need to get this well permitted so that these over 100 wells and affected operators on state, federal, and fee lands can get their drilled wells producing, and the resulting benefit not only to the state of New Mexico, but to the producers.
And June 20 is timely?
Yes, sir.
Okay. Under what rule?
Under your normal hearing rules, 20 days in advance of the hearing.
Mr. Burnoff, are you suggesting that the mailed notice was not timely?
I'm suggesting that the notice does not provide an actual opportunity for the land office to have a meaningful discussion with the applicant or to put on a technical case in 3 weeks. Acid gas injection applications usually go before OCC. Usually there's months of lead time. There's extensive analysis, both by the division, and by affected parties, the land office or others. I think it's very anomalous that this application is before OCD and not the commission. I don't know why that is. There may be a good reason for it. But I don't think we've ever seen in our time, my group's time at the land office, an AGI application getting fast-tracked the way that Mr. Felderwerd is asking for this application to be processed. I think there's plenty of opportunity in the ordinary course of the typical AGI application, for the parties to explore whether there's a possibility of resolving their concerns, and if there's not, of hiring an expert. The notion that we would be able to obtain a technical expert basically in 20 days, I think that's just not the reality of responding in any kind of detail to a case like this. The point that this is actually to our benefit, I think is patronizing, first of all, but I think also may end up being the case with appropriate safeguards, but those aren't in place. I think it's very troubling that this application doesn't, for example, propose a specific redundant well. That is one area of concern for the agency. And that's something that we'd like to be able to explore carefully and with the benefit of technical guidance that honestly, I don't think it's reasonable to expect us to scrape together in a couple of weeks.
So Mr. Felderwerd brought out the fact that your pre-hearing statement was not filed timely. What do you have to say about that?
If the tribunal wants to disregard our pre-hearing statement, I'm here to make a notice of appearance. I think that's timely under 1915-410. I don't think that our pre-hearing statement does anything other than explain the basis for our objection, which I've done here in person. So I'm not particularly concerned by that. I think given the fact that we were essentially ambushed with this application, I take the point that it may be timely as a technical matter, but as a practical matter, not really having appropriate notice and opportunity to consult. I'm happy to present our position here in lieu of the pre-hearing statement.
Your pre-hearing statement in the proposed evidence section says that the State Land Office intends to call Allison Marks, Director of the agency's Oil and Gas and Minerals Division, and Phelan Lampkin, Petroleum Specialist Supervisor. They will testify regarding the agency's position on the application. May also testify regarding potential effect on state trust land or resources of injection into the proposed well and any associated redundant well. Are those witnesses available?
No, they're not. On such short notice, it's been very difficult to line up even staff witnesses, so they're not available.
All right.
I had indicated that they would be here. Okay. It was my hope that we could make that work, but we have our lease sale today, our monthly lease sale today, and they're tied up with that.
Okay. What I'll do, Mr. Burnoff, this is the first time you've appeared in front of me, at least. I've never even met you before. Although I followed you at the Attorney General's office after you left, I joined there. So I'd heard of you, and I knew that you went to the State Land Office. I'm going to proceed with the hearing today, but what we will do is we will continue the hearing so that your witnesses can testify at their earliest convenience. That will give you a little bit of time to evaluate the evidence. We've also put together a technical review of the evidence as well. You'll benefit from hearing those questions and our technical review. But I do give the applicant deference in just about every case. I'll get to you, Mr. Felber. In just about every case that goes before us, if the applicant is ready to move forward, my job here is to hear cases and move them to the technical team for their review. I don't countenance delay unless there's a very good reason for it. So with that decision on the record, Mr. Felber, did you want to add anything?
I do, and I agree, Mr. Examiner, that you don't countenance delay unless there's a good reason, and there is not a good reason here. Okay, they received notice pursuant to your rules. They filed a untimely pre-hearing statement, but let's just put that aside, in which they said there are no procedural matters to be resolved prior to the hearing. They said in their pre-hearing statement that they would bring and have testify both Ms. Marks, Allison Marks, and Mr. Lampkin, okay? And he chose not to have them here today. My client had a conversation with Ms. Marks yesterday. In addition, if I may share, June 23rd, my client sends to Ms. Marks the C-108. I will follow up with the exact distance from the State Land Office properties. June 25th, Ms. Marks to my client. I had one of my engineers look at this, and we don't see any glaring issues. His comments were, and they go on to talk about it. Otherwise, she says, a settlement for encroaching on SLO pore space will be needed. That is what is driving this. Okay, nothing else. If not, I'm sure you want perhaps to look into his comments, likely before review by the OCC. They know review is coming up. It's worth double checking. If you can report, that would be great. As for the distance aspect, I see from the deviated bottom hole location, a distance of over a half mile from the State Land Office. And then she asked, do you have any idea where the redundant well will be? Okay, those are the two issues they raised in their pre-hearing statement. Where's the redundant well going to be, which we're addressing, and the distance from the State Land Office, over a half mile. There's no imminent concern about utilizing their pore space. Ms. Halfast gets back to her Friday, talks about the redundant well, has a conversation with her yesterday. Now, we've mentioned the need to get this case move forward. The commission, we were told by the division to bring it to the division, which we did, okay, rather than the commission. It's been pending for a while. The State Land Office has had adequate notice. They have not raised any issue other than a redundant well and the fact that they want to be paid for their pore space before we're even close to getting to their pore space. That's all they've raised, okay? So there's nothing, if they want to present a witness on that and they've said they were going to do it today, they need to do it today. There's no reason to delay the hearing on this, make me and my clients come back and delay the resolution of this. I disagree with that decision. We shouldn't countenance this type of delay when they've had plenty of notice. They've been on notice of what's going on, and they've only raised two issues.
Thank you, Mr. Felber. Mr. Birnov?
We haven't had plenty of notice, Mr. Hearing Examiner, Mr. Hearing Officer. As I've noted, it may be that the applicant is technically compliant with OCD's rules. I'm not quarreling with that. But the notion that the sky is going to fall if this AGI application, among all the others, isn't fast-tracked, I think is ridiculous. I think that you've outlined a reasonable approach. I understand the imperative to move matters that are on the docket. And so we're prepared to hear the case as presented by the applicant, but do believe that due process counsels in favor of us having a real opportunity as opposed to a hyper-technical, approximately 20-day opportunity to put a case together of this nature and complexity.
Let's deal with the idea of fast tracking. The commission and the division changed the way they're handling acid gas injection wells a couple of months ago. Acid gas injection wells will be handled as every other application is. It'll come to the division first. So there's no fast tracking in this case. What are you pointing at? The microphone's not close enough? Sorry, Brea, what'd you say? Wasn't coming close enough. Got it. Thank you. Mr. Burnoff, you heard what I said about the fast tracking. There's no fast tracking here. Acid gas wells will be handled as other applications are in front of the division first. They're not going to automatically go to the commission anymore. Okay?
I hear you.
Okay.
Mr. Hearing Examiner, 20 days, 22 days, 23 days, that's less time than a party has to answer a complaint in litigation. I understand that there are particular rules and timelines that apply to these proceedings, but I'm saying that as a practical matter, the notion that Lee Midstream tells us at the end of June that it wants to do this very close to our land, less than half a mile from our land, and has an adjudicatory hearing and then potentially gets its wish granted in the space of less than a month, I do consider that to be fast tracking compared with some of the other matters that are even on this docket today. We've heard about matters that were filed, some months ago that are now being heard. And so that's our concern.
Okay, I understand your concern. Did you enter an objection in this case?
I'm raising our objections right here and now.
Okay, and that's permissible under the rule, which ends up turning this into a contested case from a hearing by affidavit. But Mr. Feldewert, his client, his witnesses are all here today. So we're going to hear from his witnesses. You'll have an opportunity to cross-examine them. I'm going to give you a very short window to bring your witnesses to this hearing. I will continue it, but for no longer than a week from today. So, and Mr. Feldewert, your witnesses don't have to be available in person for the next part of this hearing. They can be available virtually. As so can yours, Mr. Birnoff. They don't have to be here in person.
Okay.
You need to be here in person.
That's fine.
So we'll need to figure out another day within 7 days, 7 calendar days of today, where we can finish this hearing to give your witnesses chances to testify. And I'm not hearing a formal objection to
me.
Yeah.
I am formally objecting. Okay.
Yes, I figured you would.
I'm formally objecting is, I'm sorry, but the reason we file pre-hearing statements is to let everybody know before the hearing where they stand. Okay. And if I file a pre-hearing statement on behalf of my client and I say I'm going to bring 2 witnesses and they're going to be here today, and I say I don't ask for a continuance, I don't raise any concern about needing more time, I don't raise any concern about this being quote unquote fast tracked, which is not correct, and I say in procedural matters there are no procedural matters to be heard today, okay, you're not going to allow me to not bring my witnesses, and you're not going to allow me to delay the hearing. I don't know why you're doing it for the state land office. That's my formal objection. But if things have changed, let me know. But that's not how we operate. And that's not how anybody operates over here. If they had their witnesses are here, they're available. They just didn't bring them. Okay, we know they're there. If he says he's going to bring them today, he should bring them today. And if he doesn't, that's their fault. And they didn't ask for continuance, and they didn't object to it proceeding.
So, Mr. Birnoff, there's an objection. How do you want to respond?
Well, with that gracious response from applicants' counsel, our position is that this entire matter should be continued, but we do understand the balance that you're trying to strike, and we think that that's reasonable. Again, we've been strung along by this company telling our representative, oh, we're going to come to terms, we want to reach a deal, and we've gotten nothing. And we haven't heard any details about where the redundant well is going to be. The idea like, oh, just trust us, let's proceed, authorize the AGI, and we'll deal with the redundant well at some point in the future, I think is concerning at a minimum. And it's absolutely the case that we are wanting some assurance that if and when there's injection into the well, that we're compensated for encroachment. That is part of our concern. That's been stated clearly to the applicant. And so I think that if Lee Midstream is going to take an extremist position, it's most appropriate for this matter to be continued. And if, on the other hand, it is your determination to move forward, we think that it's appropriate to bifurcate. It's not really being bifurcated, but to hold open the hearing to provide our staff an opportunity, and possibly a consultant, the opportunity to come in here and create a full record.
I'm going to take 5 minutes and come back on the record at 10:26. Thank you. All right, it is 10:26 a.m. We're back from a 5-minute recess. I'm going to rule on the objection. I sustain the objection that Mr. Folderwart made. It's legally correct. However, I'm still going to handle this hearing in the same way that I said originally. So the objection is to the pre-hearing statement. I agree that it is not timely. And those witnesses will not be able to testify in the case in chief. However, Mr. Birnoff can bring those witnesses as rebuttal witnesses. I'm going to limit the time frame to 1 week that we come back on the record and hear from those witnesses if they are needed. So I think we should make a determination at the end of today's hearing on when we're going to come back, but that's my decision. Mr. Folderwood, are you ready to present your case?
I am, sir.
All right. How many witnesses do you have?
I have 2 witnesses. We have Mr. Chris Halfast, who's the Vice President of Engineering and Construction for Producers Midstream 2 LLC, which is the parent company of the applicant. And then we have David White. He's a petroleum geologist with GLX. He's previously testified before the division and the commission as an expert in these matters. So both of these parties have filed their statements ahead of time. And those were provided to the state land office after they entered their appearance. The only thing we did, Mr. Examiner, as a housekeeping matter is we added yesterday an additional Exhibit F, which were letters of support that the company had received from a number of these affected parties. They were addressed to the Oil Conservation Division, but when I looked in the file, they hadn't been in the file yet. So they were added as an Exhibit F to our application. Otherwise, everything else stayed the same.
All right. Do we have Mr. Halfast and Mr. White here in the room with us? I thought so. Would you gentlemen come up to the witness stand, please? The button on the right side of the microphone, would you press it? It should light up green. Perfect. Would you both raise your right hands, please? Do you swear or affirm under penalty of perjury that the testimony you're about to give is the truth, the whole truth, and nothing but the truth? Yes, I do. Thank you. Would you individually state and spell your name for the record?
Chris Halfast, ChrisHalfast.
David White, DavidWhite.
Thank you. And Mr. Halfast, have you been previously accepted as an expert before this division?
No, sir.
You said no, right?
Correct.
Okay. Wait there for a moment. Mr. White, can you come close to the microphone? Have you been previously qualified as an expert before this division?
Yes, I have.
In what field?
Geology, acid gas injection well design and operation, induced seismicity risk assessment and seismic analysis, and various other topics relating to these applications.
So if you had one field of expertise, would it be geology? Would it be reservoir engineer? Geology.
Geology. Yes.
Petroleum geology?
Yes.
Okay. Mr. White, would you have a seat? Mr. Halfast, would you sit down for a moment?
Yes,
Let's
sir.
get you qualified as an expert.
Mr. Examiner, Mr. Halfast is a fact witness.
Not an expert witness.
Not an expert.
Very good. Then you don't need to. Do you want to call him first?
I do.
Then there you are.
Perfect.
Go right ahead, Mr. Featherward.
Mr. Halfast, did you review, revise, and sign what's been marked as Lee Midstream Exhibit B, which I have up on the screen?
Yes.
Okay. And does Exhibit B contain your testimony that you were offering the division here today?
Yes, it does.
And you affirmed this statement under penalty of perjury, correct?
Yes, I do.
Okay. With that said, then, Mr. Examiner, just to move things along, Mr. Halfast can be, we ask that Exhibit A be admitted, and Mr. Halfast can receive questions from the division, I guess, from the State Land Office.
So thank you, Mr. Felder. I'm just want to make sure that the basis of this testimony is not his expertise in engineering. It's literally just lay witness facts.
It's testimony about their system, the operators that are affected, et cetera. Yes.
And you're saying that doesn't require specialized knowledge?
Well, as a fact witness for the system, yes. I mean, it requires knowledge of their system. I suppose if you're comfortable, we can get him qualified as the expert in petroleum engineering.
Let's get him qualified. I'll get you qualified. That way there's no question about your testimony.
Not a problem.
Thank you. What education do you have? And give me some dates and degrees. What education do you have that goes towards petroleum engineering?
Bachelor's degree in chemical engineering from the University of Texas.
Dates?
2004. Graduated in 2004.
Okay. Okay, is that it?
Yes, sir.
Okay.
Yes, sir.
And then since 2004, what work have you done in petroleum engineering?
I have been, ever since I graduated college in 2004, I've been in EPC engineering and design for all kinds of different oil and gas engineering. So my specialty has been midstream natural gas for the past 15, 20 years. I've designed multiple cryogenic processing plants, amine treaters, fractionators, all across the country, gathering systems, compression stations.
Who have you worked for since 2004?
First started off with plant process equipment down in Houston. We were an EPC company. Then I moved on to gas technology, where we built, designed, and leased and sold amine treating plants. Then I moved on to PVR midstream. We were a oil and gas midstream company. We got acquired by Regency Energy Transfer, or Regency Energy Partners, which later turned into Energy Transfer. Then I went to a private equity-backed Cayman Energy. We built and designed the Blue Racer system up in the Northeast.
Instead of telling me what we did, I want to know what you did. So
I
what
was,
your title was, what your job duties were.
I started off, so I've been process engineer at PBR Midstream, project engineer and project manager there. I was a process engineer at Plant Process Equipment. I was project engineer, process engineer, and project manager at Gas Technology. At Cayman Energy, I started off as a project engineer and then moved up to manager of engineering and director of engineering. After that, I left and went to Align Midstream, which was another oil and gas midstream company, where I was vice president of engineering and construction. And then I went to EnLink as a senior project manager. And now I've been over at Producers Midstream for almost the past year as vice president of engineering and construction.
All right. Mr. Birnoff, any objection?
To qualifying this witness as an expert?
Mm-hmm.
No objection.
Excellent. You are hereby, before this division, recognized as an expert in petroleum engineering. Now, Mr. Feldwer has already asked if you adopt this self-affirmed statement under oath, and you said yes. Is there anything further from this witness, Mr. Feldwer?
No, sir.
Okay, very good. Mr. Birnoff, cross-examination?
Mr. Halfast, am I saying your name?
Yes, sir.
Mr. Halfast, is the relationship between company that employs you and Lee Midstream? It's a different name, right?
It is a different name. Lee Midstream is a subsidiary of Producers Midstream.
Fine.
I don't have the exact date. I started with Producers Midstream in August of last year, and this work had already commenced by the project team. So it was in 2024 Yes, sir. I don't have that information in front of me.
It's okay, it's in the record.
Perfect.
You remember approximately when it is?
March of this year.
Have any communications with any staff at the New Mexico State Land Office about this AGI, this proposed AGI?
I have, yes.
Do you remember who from the State Land Office you had communications with?
I've reached out to Allison Marks.
And who was Allison Marks?
I believe she is the director of the SLO Land Division.
When did you reach out to Allison?
It was towards the end of June.
And what was the purpose of your outreach?
It was an introductory call to let her know that we are submitting this application and having a hearing with the OCD and develop a relationship with the SLO. I personally had not, but parts of my team have been involved on right away for our pipelines and some of our business leases with compressor stations.
And what was the outcome of your discussions?
We had a very good introductory call. She had sent back a few follow-up questions, and David White and myself discussed them. And I did reach back out to her last Friday, and I believe she was on vacation. And I followed up with an email to her discussing some of those details. And then her and I did have another phone conversation yesterday.
Okay. What is your understanding?
There was two concerns. One of them was location of the redundant well, and the other was pore space lease negotiation.
What did you tell Allison Marks about the location?
I said it has not been finalized. We are waiting on additional information from drilling of the well and some 3D seismic information so that we put it in the most optimal and safe location.
When does Thanks for the reminder. Okay. When does Producers Midstream or Lee Midstream expect that it will determine the location of the redundant well?
I will defer to David White, our expert, when he comes up here.
And you had mentioned David White during your testimony. Did David White join you in any discussions with Allison Marks of the Land Office?
Not personally on the phone. I did copy him on one of the emails, a response to Allison.
Okay. Were there any other issues that you and Allison Marks discussed regarding this application other than the location of the redundant well and pore space encroachment?
No, sir.
Did you and Allison come to any conclusion regarding pore space encroachment?
She had sent over an agreement that the SLO and Targa had previously entered into towards the end of 2024. And we just got that over yesterday afternoon, started reviewing it. We are committed to working with the SLO and develop a relationship and working towards an agreement here.
Did you tell Allison Marks in your conversation with her yesterday that you would get back to her by the end of the day, meaning yesterday, with a compensation agreement?
I do not believe so.
Did you tell Allison Marks in your conversation yesterday, that's July 14th, that you would get back to her accepting or rejecting the proposed compensation that the State Land Office was seeking?
No.
Did you provide Allison Marks with any time frame for when you would get back to her on the pore space encroachment issue?
No definitive date.
Do you have in mind any definitive date for when you will get back to the land office, if ever, on the pore space issue?
I have no problem reaching back out to Allison and discussing this matter this week.
Who is the decision maker at Lee Midstream, Producers Midstream, for matters like this, reaching resolution with potentially affected parties like the land office?
Myself, I have the ability to make this decision, but we go through our executive team and discuss this as a group.
Okay, just so I understand, so you can make the decision yourself, but you need to visit with other people in the company?
Yes.
It doesn't require a supervisor to approve compensation or lack of compensation for the land office, rendering a decision on this issue?
I'm not following your question.
You don't need to go to anybody else to get approval if Lee Midstream or Producers Midstream is going to take any definitive action in this area?
I will discuss it with our COO, our Chief Operating Officer, James Hager.
Okay. Did you tell Allison Marks in your conversation of July 14th yesterday that you would talk with any of your colleagues or with James Hager and then get back to her, Allison?
Yes, I did. I said we would review this as a group and I'd get back to her.
Okay, but again, you didn't offer any particular time frame for doing that?
No, sir. I was catching a flight here.
Okay. Do you believe that the state land office is entitled to compensation for prospective encroachment into its pore space?
Object to the form of the question, calls for a legal conclusion. A legal conclusion?
Mr. Berger? As a business and operational matter, I'm asking if the witness thinks that the state land office, if there's any merit to what the state land office is asking for, not asking for a legal. The objection was I'm not asking for a legal conclusion. I'm asking for what this particular witness thinks is reasonable as a business matter.
So I'm going to sustain the objection.
So, Mr. Halfast, do you believe that the state land office is entitled? Do you believe that there's any reason for your company to pay money to the state land office for the state land office's claim that injection would encroach on its pore space?
Let me object. You're talking about in this circumstance where the well bore is over a half mile from the state land office acreage? Talking about that circumstance?
I'm talking about the circumstance where the well bore is less than 1/2 mile from state acreage, as in this case.
The bottom hole location is over a half mile, according to Ms. Helms.
The surface location is less than 1/2 mile, and that seems pretty dispositive here. In any case, we're talking, Mr. Hearing Officer, about this circumstance, this particular well, not generally.
So what is your objection?
So, okay, it sounds like he's asking two questions and it's not quite clear. It seems to me that the question at this point is somewhat vague, but if he wants to pinpoint it to this particular circumstance, both from the surface hole location or the bottom hole location, then I don't have an objection.
All right, so will you be clear with your question when you ask the witness this question?
I'll do my best. In this particular circumstance, you understand we're talking here today about the White Russian well?
Yes.
Okay, so for the White Russian well, do you believe that there's any reason that Lee Midstream or Producers Midstream should pay the state land office any amount of money based on the location of this well vis-a-vis state trust land?
I will defer to our geology expert, David White, and what has been previous experiences. This is my first dealing with an AGI well.
So my question is not about geology and it doesn't call for geological expertise. I'm asking, as a business matter, do you believe that there's a reason why your company or companies should pay any money to the state land office, again, for the location of this well, White Russian, vis-a-vis state trust land?
I object to the form of the question. I think he's testified that he doesn't have the background or the experience to address the question.
And Mr. Hearing Officer, this witness is being presented as a representative of the company. I'm not asking about geology. I'm asking about the company's business and operational decision-making. And I think that's an appropriate question for a corporate representative.
And I think he tested, I'm sorry.
Hold on a second. You ask him some questions to provide a foundation for your question.
I'm happy to do that. So, Mr. Halfast,
The objection was.
Mr. Halfast, what again is your role at Producers Midstream? Will you remind us?
Vice President of Engineering and Construction.
Okay, and what are your job duties as Vice President of Engineering and Construction in general?
To lead and design our gathering, processing, treating, engineering, pipelines, compressor stations, plants, and the construction and execution of the projects.
Okay, and do you, in that capacity, do you enter into any contracts?
I deal with contracts with contractors that execute pipeline construction, facility construction.
Okay, and what about permitting? Permitting like this one, the application that we're here for today?
No, I have not entered into permitting contracts.
Are you involved in the process of applying for regulatory permits like this one?
Yes, I am.
And will you describe the role that you played in preparing this particular application for White Russian?
I have reviewed the data that our consultant GLX has put together. We discussed the design of the well and looking to push through for an expedited review.
Okay, and you testified that you reached out to the state land office to develop a relationship. What kind of relationship are you looking for with the state land office?
We have dealings with our pipeline right of way and compression stations and looking to establish a good relationship to continue our business dealings with them.
Describe your role in having or promoting business dealings, on behalf of your company with the state land office.
So we have our team and our right-of-way consultants that work with the SLO and other landowners with our pipeline routes, our compressor stations. So we do go through and discuss optimal routes and compensation for those.
Okay, and you testified that you, with consultation with others at your company, would be empowered to make a decision whether or not to provide any compensation to the state land office for this well, the location of this well, right?
Once we receive a proposal, yes.
Okay, and so I'm asking, what would be your criteria for determining whether or not Lee Midstream, Producers Midstream should provide any compensation to the state land office?
Previous examples that GLX and our other consultants have dealt with in the past.
So you'd look at previous examples, but how would you decide, because you did testify that you're the decision maker, how would you decide whether or not to proceed with any compensation?
Once we see what the proposal looks like, then we'll review it and decide whether it is a agreement that we can move forward with.
And so I'm asking, coming back full circle, do you believe that this, as a business representative, as a vice president of your company, who has the power to make a decision over whether or not to enter into a compensation agreement, that the land office should get any compensation in this situation.
Object to the form of the question at this point in time or at some point in the future when the encroachment is more clear.
Well, I'm happy.
Okay, hold on.
Okay.
Hold on. So the original objection, after hearing his background and understanding his role in this more clearly based on the foundation laid by Mr. Birnoff, is sustained. However, Mr. Birnoff asked a different question, which I thought was easily answered by the witness, which is, what is the criteria you use in determining whether compensation is possible or not? And now that we've gone down that road, which I think is fair road, I agree that the last question you asked is not. It doesn't build upon that criteria aspect of it. So I'd like you to stay within that criteria aspect that you asked and ask the question you want, but keep within that area.
If I may, Mr. Examiner, lodge, now that we've heard all this, lodge one other example, okay, or objection, and that is the issue before the Oil Conservation Division is whether this well should be permitted based on the criteria utilized by the Oil Conservation Division. This whole line of questioning about what should be done with the state land office, whether the state land office is entitled to pore space compensation, at what point in time should the state land office be entitled to pore space compensation, at what distance, et cetera, is not an issue that the Oil Conservation Division gets involved in. So I don't know why we are spinning our wheels addressing those issues that have nothing to do with the matter before the division. I've given them some leeway, but I don't understand why we're going down this route.
So I think the objection, Mr. Birnoff, is relevance. However, I think you waived that objection a while ago. I mean, this has been going on now for 10 minutes, and we've now learned a lot of information that maybe we didn't need to know or not. So, Mr. Birnoff, it is on the outskirts of relevance at best. So please wrap up this with one more pointed question to this witness, building on your criteria.
I will do that, Mr. Hearing Officer, and I'll just note the waiver issue, I think, is real, and it's not just because of me asking questions and not having objections. I appreciate counsel being courteous in that respect. Counsel has introduced to you, to the hearing officer, emails from my office. He has opened the door to this issue. He can't have it both ways. He wants to say, we need to move forward today, and we got to hurry up and get this issued because the state land office is going to benefit from it, and because the state land office said things are going well in terms of these discussions. So I think it's appropriate for us to explore it. I take your admonition to move along, and we're going to do that. So what I want to know, Mr. Halfast, is how will you make a decision as to whether or not the state land office, whether your company will or won't provide any kind of compensation to the state land office, again, for the White Russian well?
Once we receive a proposal from the state land office, we will review it, look at the commercial implications, and proceed from there. We are committed to working with the state land office.
Okay, well, I certainly appreciate that. Do you believe that acid gas injection, assuming that the White Russian well is permitted and injection commences, could interfere with other disposal within, let's say, a half-mile radius of that well?
I'm not an expert in geology and reservoir engineering.
Okay, but you're a petroleum engineer, right?
I'm a chemical engineer.
You're a chemical engineer. Do you have any expertise that would bring to bear on the location or the geology of this particular well?
No, I do not.
Would you defer to David White? Do I have that name right?
Yes.
You would defer to him on those matters?
Yes, I would.
Okay. No more questions from me.
Thank you. Mr. Geber-Michael?
Yes, Mr. Hearing Examiner, I have quite a few questions for the expert. Not for Mr. White. Not for the
Nothing for Mr.
No,
Alvarez.
not for the health fund. Sorry. I should have skipped that.
Mr. Feldowert, redirect.
No questions.
Thank you. Okay, you may be excused.
Thank you.
Although you may end up coming back for rebuttal, either here or virtually at some point. Mr. White. Mr. Feldowert, who's the other gentleman in the back of the room?
I'm sorry, the other gentleman is Mr. Will McCraney. He's the chief commercial officer with the company. He was not listed as a witness.
Thank you. Mr. White, is your microphone on?
Yes, it is.
Okay, very good. Mr. Feldowert?
Good morning, Mr. White. Would you state your full name for the record and identify by whom you're employed and in what capacity?
David Allen White. I'm employed by Geolex Incorporated as the vice president and senior geologist.
And Mr. White, did you prepare the Form C-108 application that has been filed with the division?
Yes, I did.
And did you also then address the revision to that C-108 application that was subsequently filed with the division?
Yes, I did.
And did you not only prepare it, but did you affirm it as needed for per the requirements of the form?
Yes.
And that C-108 application, the revised form that was submitted to the division, has that been marked as Exhibit A to Lead Partners hearing package?
Yes, that's correct.
And then your statement, has that been marked as Exhibit C to the hearing package?
Yes, it looks like it.
And you affirmed that statement, correct?
Yes, I do.
And you note in paragraph 2 your areas of expertise for which you've been qualified to testify before the division?
Yes, that's correct.
Okay. Mr. Examiner, I would then present Mr. White. Actually, I move the admission of Exhibit A and C in the, I don't think there's any subdivision, sub-exhibits, and then tender Mr. White for questioning from the division.
Thank you. You said A and C. Did you not want to move all your exhibits into evidence?
Oh, we certainly can. It would be exhibits A through F.
Mr. Hearing Officer, I am going to object to the admission of F. That is the testimonials from oil and gas companies. You know, I don't think that the applicant should be able to raise what I think is this inordinate fuss about our timeliness of our participation in this proceeding and then sneak in all of these letters, which are also cumulative. And I would also say are of limited evidentiary salience to this matter. So we do object to that.
Okay, all right. So Mr. Feldowert, exhibits A through E are admitted through stipulation, basically. There's no objection to them. When it comes to supplemental exhibit F, which I have not had time to review, why are they relevant?
You'll see, Mr. Examiner, that all of these were directed to the agency with respect to this case. And they all indicate the need for acid gas disposal in this area. These are for producers who have wells that have been drilled that are waiting for acid gas disposal options. And so they wanted to inform the division of the need for this well, and that they support approval of this disposal option as soon as possible.
Okay, so what is the relevance of these exhibits?
So the relevance is A, the need for the disposal well, which I think is a relevant factor. It's also relevant to our request for an expedited treatment due to the lack of disposal capacity in this area. So they haven't asked to be parties. So there's no deadline for them to send this in, and they sent it in by way of a letter.
And it's the applicant who's submitting these letters, right? It isn't that Cimarex or Lario or anybody else is asking to weigh in on the sidelines. The applicant wants to beef up its application. I ordinarily wouldn't object to that, but given the strenuousness, the council's objection to our filing an appearance, participating in this proceeding, I think for the sake of consistency and fairness, it's appropriate to not let exhibit F in.
Well, let me step back. I didn't object to their witnesses. They chose not to bring them. Okay. Number one. Number two, I didn't object to his appearance here today. He has every right to be here. He got notice and that's why he's here. Number three, these are operators out there who are directly affected by this application. Many of them operate on state lands, which have wells drilled on state lands. And so it does have a bearing on the importance of this, and it does have a bearing on the need for the disposal capacity in this area.
All right. Hold on. I've heard from both parties. Thank you. I'll make a decision. I'm going to reserve my judgment on this issue. So F is not admitted as of this moment. By the end of the hearing, we will deal with this. I will come back to it. Okay. So all of your other exhibits, A through E, are admitted into evidence. Is this witness now ready for cross-examination?
Yes, sir.
Okay. Mr. Birnoff.
Okay, Mr. White, I just want to clear up. Have you had any communication with Allison Marks or anybody else from the New Mexico State Land Office about this particular application? White Rush.
No direct correspondence.
You've been CC'd on messages, but that's the extent of it.
I have been provided some email communication with questions from the State Land Office regarding the redundant well location and provided some feedback to those email correspondence.
Where is the redundant well location?
Like many acid gas injection well projects, the location of the redundant well is not yet known at this time. Ultimately, the scale of these projects and their importance to a gas treatment facility or gas processing facility is such that, you want to gather as much available geologic data as you can, which includes those data that are yielded from drilling the first well in finalizing and siting a location for that acid gas injection well. It's expected at this time that second redundant well, which my client has been aware of the expectation that a redundant well will be part of this type of project in New Mexico, that the location of that well will ultimately be determined by data yielded from drilling the first well and any ongoing analyses of the project area that continue down the road.
Okay. So the location of the redundant well could be very close, and let me be precise about that. It could be less than half a mile from state trust land. Is that right?
I don't think it's known at this time. Ultimately, from an operations perspective, it's often good to have the surface locations of these wells very close to each other or relatively close to each other, so that from a personnel safety standpoint and an operational safety standpoint, they're kind of together and isolated from heavy foot traffic at a particular facility. But where the optimal bottom hole location may be towards state land or maybe away from state land. And at this time, we're only proposing one well with a definitive point of injection and proximity to the state land.
Okay, and since it's not known at this time where the redundant well will be located, it is possible that the applicant, Producers Midstream or Lee Midstream, will try to locate the well half a mile from state trust land or less, right?
It could be that it is within half a mile of state trust land. However, that redundant well, while it's often required by the approval of a first AGI well, it is not approved through the process of a first AGI well application. And it will have its own C108 application that is prepared where the subsurface is analyzed and the location is considered, and a request for that location and application will be accompanying that redundant well project.
Have you been retained by Lee Midstream or Producers Midstream to study the location for a redundant well?
Not at this time. There have been no engagements specific to the redundant AGI well location. However, we are retained as geologic support experts for analysis of their project area, for development of this application being heard today, and as currently as the project continues forward.
Have you, and when I say you here, I mean not just yourself personally, but anybody that's from GeoLex that's working with you or under you, have you conducted any analyses for determining the appropriate location for the redundant well?
We have completed the analyses that are present and communicated in this application. However, we understand that moving forward, the data collected from drilling the AGI #1 well, as well as any additional data with respect to offset wells, other projects in the area, or additional data commercially available that is attained by or acquired by Lee Midstream would be utilized in future efforts and in future siting of a redundant well.
Are there any analyses that you or your colleagues have performed regarding the potential location of a redundant well that have not been included in the application that's before the Oil Conservation Division today?
No, currently there is no tentative redundant well location or any forecasts or modeling that have been done to explore any potential locations.
And Mr. White, I think you said, and correct me if I'm wrong, that typically, or maybe you even said ideally, the surface location of a redundant well would be located at the same place as the primary well. Do I have that right?
If the reservoir and the subsurface attributes are suitable for that to be the case, then yes, having those process units at the surface in locations that minimize foot traffic and personnel interaction provide a safer option. In the event that that's not available, so should it be with respect to reservoir capacity or reservoir quality, then other opportunity or other options might need to be explored.
Have you presented a recommendation to Producers Midstream or Lee Midstream that the redundant well should be located on the same pad or at the same location as the primary well?
No, I have not. And that's ultimately because, that recommendation, may not be a good recommendation. Should it be the AGI #1 well is drilled and it's drilled in a location that is unsuitable for injection? Ultimately, the goal of these wells is to reduce waste, reduce release events, and, providing that professional recommendation that a well should be in the same place as the first well may turn out to be a very bad recommendation should reservoir attributes not be suitable for that.
Do you know when in time, approximately, I'm not looking for a date, certainly, when in time Producers Midstream or Lee Midstream intends to make its determination about the location of the redundant well?
Mr. Examiner, I don't want to waive anything. And I do like to give council a little leeway, but the redundant well is not at issue here today. What is issue here today is the White Russian #1, for which the C-108 application has been filed. So I don't know why we're going to go down the road and discuss a redundant well that, if and when it's permitted, will require its own hearing. Relevancy.
My response is simple. The redundant well is something that Lee Midstream says that it's going to move forward with. I have questions that I think will establish, at least from this witness, the importance of having a redundant well. And certainly we flagged it as a concern of ours. And so we're being told on the one hand, oh, this is irrelevant. And on the other hand, oh, we've got this covered and we're going to take care of it and it's going to go fine. So I'm not sure which one it is, but as long as this is a live issue, I think we should be able to explore what the company's intentions are. Okay, Mr. White, do you think it's important for an acid gas injection well to have a redundant well?
I think, yes, I think in general it is.
Have you participated in any oil conservation division or oil, conservation commission proceeding where an acid gas injection well applicant, a company that wants to drill and inject an acid gas injection well, has not had a redundant well at all?
I have not participated in any. There have been, prior to probably 2018-ish, numerous acid gas injection wells that have been permitted as singular well projects. Since that time, I think it has been, every order issued by the division and or the commission has come with conditions of approval for a redundant acid gas well at these facilities. Based on that precedence and that normal procedure and requirements of a permit, we don't expect anything different from this. Those conditions of approval from the commission and the division often come with very straightforward timeframes with respect to when that redundant well application should be submitted, and when that redundant well should be in service. And like I said, I think the existing protocols are really the vehicle for defining and determining the appropriate location for that well, the application that requests approval for that redundant well, and the timeline you're expected to do it.
And you testified a minute ago that in general, you think it's a good idea or it's important for acid gas injection wells to have redundant wells, right?
Yeah, I think any redundant process when it comes to injection wells or process units that minimize waste and reduce flaring. Yeah, absolutely. I think it's a good idea to have that be a redundant system.
Why is it a good idea in this context, acid gas injection?
To simply put, it allows operators to maintain compliance with respect to waste rules, while continuing to maintain operation of process units that are really preferable for the safety and the operational stability of facilities.
Tell me more about safety. What are the safety reasons, if there are any, that there should be a redundant well for an acid gas injection well?
Well, I think acid gas injection wells in general are throughput processes. They don't involve as much in terms of potential exposure to personnel at the facility. They result in the sequestration of gases into deep geologic formations where they're permanently contained and ultimately don't have the same challenges as some alternative sour gas processes.
Okay. And with these answers, what you've told us about redundant wells in general, let me return to the question that council objected to with the objection overruled. And let me ask you, do you know when in time your client here intends to seek permission, authorization for the redundant well?
Well, I think that would ultimately depend on two things: the availability of data from drilling of the first well that is being proposed. It would be potentially, it could be a potential issue to commit to a second well location when you don't have the data, whether that be geophysical log data, injection zone testing data, or anything from the first well before committing to the second well. So I think, the question of when becomes how much data do I have? What do the data from the first well say about the injectivity potential of the reservoir at this location, as well as what is the timeline in which I am required to site a location, develop a C-108 application, and continue the process, the division and or commission process with seeking approval to drill and complete that redundant well.
How will you know when you have enough data?
I don't think there's any point in which you have enough data, but I think having a key data points from this proposed White Russian AGI #1 well location that are reflective and collected at the facility are going to be critical pieces of data that should be reviewed before committing to a final location for any redundant well.
So it sounds very open-ended to me. It could be 6 months, it could be 6 years, it could be 15 years, right? Before
No,
you
I
have
don't
enough
think so.
data? Well,
No,
so help me understand what the time frame is.
I think the application process and the expected conditions of approval from any such order approving AGI #1 would not allow it to go to very long periods of 6 years down the road here.
You mentioned expected conditions of approval. What are you expecting as an expert, the Oil Conservation Division, to require in terms of when the company comes back and seeks approval for a redundant well?
I think the best answer to that question would be to look at recent conditions of approval for various acid gas wells by the division or the commission.
Well, but you mentioned having expectations about conditions of approval, so I'm asking you what you're expecting.
My expectation is that a condition of approval for AGI #1 proposed today will have a schedule for which the division or commission would expect to see the C-108 application for the redundant well to be submitted, and a schedule and date for which the redundant well would be drilled, completed, and in service.
You don't have any idea, sitting here today, giving testimony, what that schedule would look like?
I think there have been, with various orders, I think there have been a variety of schedules put forward.
What's the range of schedules that you can recall?
I believe the range of schedules would probably be within 1 to 2 years.
Within 1 to 2 years of issuance of authorization to inject for the primary well? Within 1 to 2 years of what?
I think it really depends. I think there are orders in which the redundant well application be submitted within 1 year of issuance of the first permit. I think there may be examples of the redundant well application being required 1 year after drilling and completing of the first well. I think there's a variety of them that may be, there's no one simple expectation. I think that's at the decision of the commission or the division.
Are you offering any recommendations either to the client, Lee Midstream, or to the division regarding the appropriate schedule condition for the redundant well that would go into any authorization?
No, I am not.
You don't have an opinion about what that timeline should look like?
At this point, my client nor the division or the commission has requested I make any recommendation with respect to that.
But I'm asking, do you have an opinion about the appropriate timeframe, a professional opinion?
I have no specific opinion about it. I think the process of the division and the commission and their conditions of approval, I have no objection to those, no issue.
Okay, and I just want to confirm, you have not been retained at this point in time by Lee Midstream or Producers Midstream to perform any further studies on the location or the appropriateness of a particular location for the redundant well, right?
My existing retention to provide geologic support services and project area analysis services is still active. That is a current retention. The current scope of that retention is focused on the application for the AGI #1 well.
Okay, I'm sorry. You say focused on. You have not been, just to be really clear, you have not been asked to prepare a redundant well application as of today.
No, I have not.
Okay. You mentioned earlier in your testimony, Mr. White, that you've seen, I think, some instances of acid gas injection well applications being submitted and maybe even being approved by the division or the commission without a redundant well? Can you think of any specific examples where that has been the case?
I mean, they would be quite older orders. At this time, I mean, nothing beyond probably 2018, 2017 would have come out with a singular acid gas well.
Okay, and what about applications? Here's a slightly different question. What about applications where a redundant well is contemplated but is not identified when the application for the primary well is filed? Can you think of specific instances, let's say since 2018, before this body, where such applications have been filed? Other than this one?
To be clear, are you asking for an example of an AGI well application which was approved, did not by the applicant propose a redundant well? I'm just trying to make sure I understand your question.
That's fair. We'll get to approval, but let's just talk about the application stage first. Do you have in mind, since 2018, any specific application for acid gas injection where no redundant well location has been proposed?
Yes.
What are those examples?
The application originally filed by Ameridev in 2019 proposed an acid gas injection well at their facility. The original application did not propose a redundant well, did not discuss a redundant well. The condition of approval by the commission, however, did, as I described before, require a redundant well. It did specify a timeline for that redundant well being drilled and put into service and the relevant application processes. And that well, did not propose that redundant well from the initial application. Would you like another example?
I would like another example, but first let me ask you, were you a participant in the Ameridev application?
Yes, I was.
Were you a consultant for Ameridev?
Yes, I was.
Did any parties during that proceeding raise concerns about the lack of a specific redundant well location as part of the primary well application?
Not that I recall.
Okay. But nonetheless, the location of a redundant well, that was made part of the conditions of approval.
It was.
Okay. What are the other examples that you have in mind?
Another example would be the original application by Salt Creek Midstream.
And when was that application filed?
2019, I believe.
And were you a consultant for Salt Creek in that matter?
Yes.
Okay. And similar to Ameridev, was a condition regarding a redundant well imposed by OCC or OCD as a condition of approval?
Yes, it was.
Do you know why it was?
Why a redundant well was
what was
included
required?
in a condition.
Do you have an understanding of why that condition was imposed?
Off the top of my head, I can't recall the specifics, but
okay.
So at this point, no, I don't recall.
Since 2018, are you aware of any specific instance of an acid gas injection well application being authorized, being granted without the requirement that there be a redundant well?
Not that I can recall offhand.
Okay. Okay. No more questions.
Let's turn to Mr. Emilian Gebremichael, the technical examiner in this case. Would you spell your name for the record, please?
Yes, my name is Million Gebremichael, Million, and my last name is Gebremichael, Gebremichael. Right, I proceed. Yeah, I have a few questions for Mr. White. If I may direct your attention to page 49.
Let me, would you like me to share?
Please.
Yes.
Certainly. Is this what you're looking at, Mr. Examiner?
I wish you could go to the one that I referred, the one with yeah, that's fine.
I'm with you. This one has 112 pages.
Yes,
That's the one you
so
want
on
to use?
that one, page 49, please.
Sure.
Thank you.
There we go.
It's Exhibit A, page 49. Yes.
Just for the record, this would be the initial Exhibit A filed with the division.
Yeah.
On. Hold on.
I think on 7/9/25.
7/9/2025.
2025, yes. So my question is, Mr. White, you're planning a complete acid stimulation after your spot acidization. Would this acid cause dissolution of the carbonate in the secondary carb rock and the interval, the Mississippian Formation or the Mississippian section above the Woodford Shale?
No, I don't believe so. The stimulation program will ultimately be designed to improve injectability at the well location. And with the open hole injection zone that's being proposed being limited to the Siluro-Devonian interval, I don't think there would be at the well location any potential that would cause any dissolution of those units. I think, significantly farther away from the AGI well, where as is depicted in this cross section that you referenced, I think we don't see any migration of fluids up structure to reach any of those features depicted here, and I don't think any stimulation treatment would have any impact over the greater project area.
Do you have any control mechanism on the extent of your acid stimulations?
Not offhand. I think in consulting with a service provider that would help design and finalize that stimulation program, those details and the lateral extent could be determined. But at this point in the very, very pre-construction process, those drilling and completion activities would still be in flux a bit.
Yeah, my worry in this aspect is the Woodford Shale is thinner, and this part of the reservoir is around 169 feet. Mm-hmm. So probably a good control mechanism would be helpful on this one.
Mm-hmm.
All right, if I may direct your attention to Exhibit A, page 44. Mr. White, as you can see, the overlaying pay zones depicted in the diagram, starting from Yates all the way to the Wolf Camp, they may pose the risk of loss of circulation. How are you planning to mitigate this? Are you planning to deploy managed pressure drilling?
I'm sorry, excuse me.
So those pay zones are permeable zones, right? If you see on the diagram, starting from Yates and all the way to Wolf Camp, those are oil and gas pay zones, right?
Yes, I see.
As you drill, there may be a risk of loss of circulations. So how are you planning to mitigate any loss of circulation, either during cementing or drilling? And then if you are planning to utilize the managed pressure drilling, those are my questions.
So I think in terms of drilling and completion of the well, those drilling and completion plans are still being developed. I don't disagree that some sort of pressure management would be a good idea for some of those zones. I think ultimately the decision to utilize a managed pressure drilling system would be evaluated as the mud programs are developed and the drilling fluid records of those offsetting wells are evaluated by the drilling contractor. I think if appropriate or if evidence is present that seems it would be necessary or beneficial to utilize those in this area, I think that would be a good idea.
So in your drilling program, maybe refer to past mud density, utilized in this part of the well?
I think that would be part of it, and consultation with the mud engineers and the drilling fluids engineers that have been drilling in this area to make sure that our plan is appropriate for this position within the basin, this location within the basin.
Okay, perfect. So you're aware of that. All right. If I may direct your attention to Exhibit A, page 38.
PDF 38?
Yes, yeah, got it right. Mr. White, as you can see on the table, both the active SWD well, which is the Wild Ray SWD well, which is approximately 1.1 miles away, and then you got the plugged and abandoned well, the Toro 21, which is within 2 miles. I'm not sure exactly how far, but it is within 2 miles of the proposed well. Both these wells penetrate the injection zone of the proposed wells. Both were completed with non-CRA, the corrosion resistant alloys, and then non-corrosion resistant cement as well. Given your proposed secondary porosity creation with acid stimulation, and then your calculation of the plume occupation area of 3.24 square miles with a 1.47 miles extension to the northeast, do you think these two wells will be encompassed by the proposed well's plume or engulfed by the plume?
So with respect to the plugged well, the current forecasts for the operation of the AGI #1 well do not suggest that it would reach those. As you had described, the anticipated maximum extent from the point of injection is currently anticipated by our reservoir modeling and injection simulations to extend about 1.4 miles from the point of injection. Now, that is not to say that is, the gospel or the absolute an absolute accurate forecast, but at least under those very conservative conditions, we don't expect the plume to reach those distances away. With respect to the Wild Rye SWD well that you mentioned, that well is currently located to the southeast of the applicant's proposed facility or proposed well location, and is outside of those same reservoir modeling and forecasts anticipated acid gas injection plume. So I think in both of those circumstances at this time, as we understand it, we don't expect those to be in contact with acid gas. However, I think, as they are appropriately required to be identified in the application process, I think continually keeping an eye on where our plume forecasts are suggesting acid gas is going with respect to the relationship to those wells, I think is important.
So you mentioned the total aerial occupation of this plume is going to be 3.24 square miles. And then these wells are within 1.1 mile and 2 miles. And then you're planning to carry out acid stimulation for secondary porosity. God knows where it's going to take you. So you don't think they're going to be affected?
I don't think so. I think ultimately, the acid stimulation is really designed to only improve injectivity really kind of near the point of injection, and isn't designed to have any far-reaching improvements to secondary porosity. So I think as you're getting toward the distance to these wells, I don't think you have any stimulation program that really impacts those substantially. And I think as part of the exhibits, we do provide plume footprint maps for various case simulations that show the anticipated footprint of the plume kind of moving up structure to the northeast as a result of buoyancy effects and not towards the direction of the wild rye well.
Okay, I'll proceed to the next question. If I may direct your attention to Exhibit A, page 43. I just want to confirm in the past that you did utilize CRA for this one, but I just want to confirm, are the control line and the valve flapper made of the corrosion resistant materials?
Yes, they are.
Yeah, okay. All right, I'll proceed with to the next question. If I may direct your attention to page 19, 19. So, Mr. White, are the downhole pressure and temperature monitoring devices connected via cable to a SCADA system?
Yes, they are.
They are. Why did you not propose utilizing new technologies? Like I'm sure you've done that in the past, like fiber optic data to transmission, like DAS and DTS, for real-time data gathering? Or do you have any plan with a redundant well? And
well, I mean, the data collect or the downhole data collection plan at the moment is real time tied into SCADA, providing continuous observation and recording of those data. At this time, no, at this time, we don't have any data objectives that would require or for which we would propose a DAS line or a fiber optic acoustic line to be installed in this well. At this point, we don't have any indications that would provide us something that helps us better evaluate this site or monitor this site outside of the continuous monitoring we already propose.
Mm-hmm. I do understand that, but as far as using the annulus for mechanical integrity monitoring as well, but this new technology is also they providing with images for back channeling and all those things. I'm sure you did apply those with other cases. Do you have any historical experience that they have been applied in practice? And then
I have some. I think ultimately some of those technologies are relatively new.
Yes.
And so not a lot of historic precedents of seeing them in wells, seeing the data they provide or their utility.
Mm-hmm. I didn't see the cable that is connecting the bottom hole gauges and the wellbore diagram. Is it there?
I don't know if it's depicted on the wellbore diagram. It is a physical TEC cable that will connect to the downhole sensors, be clamped along every joint of the injection tubing, and run to surface.
Okay.
I don't know if it's visually represented or not.
I didn't notice it, but we'll check with that one. If you check as well, that would be great.
Mm-hmm.
All right, I'll proceed to the next question. If I may direct your attention to page 60. Okay, Mr. White, as you could see on the bottom diagram at the top, it says the FSP model predicts minor potential for induced slip in response to the adjacent SWD injection well. I'm assuming that was the well dry well, maybe? No?
No. So ultimately, the kind of investigation area of the fault slip probability modeling is a pretty large area. We collected and compiled well data and operating data from wells far to the northeast, which include, I think, a few SWD wells that have been in operation for a number of years, for which I I think they range from about 6 to 8 miles to the northeast, which they're represented in the map shown on the screen.
What was the mileage you say? 6 to 7?
6 to 8 miles
6 to 8 miles.
to that northeastern fault and that other cluster of SWD wells. The wild rye and the exhibit shown on the screen would be just to the lower right of the annotated AGI #1 well.
Okay. Okay. Well, the point that I'm trying to get at is as you may be aware, the operator of the active injector well, the wild rye SWD well, is requesting an injection rate increase to 50,000 barrels per day from OCD. Do you think an injection rate increase would increase the potential for induced seismicity? I mean, after years of injection from the proposed AGI well, and then maybe the subsequent redundant well, and then the active SWD well, the combined downward migration might affect the basement rock, and then maybe the risk of seismicity.
So I think that question ultimately, needs to be addressed by, our continued understanding of the reservoir attributes. At this location, we see wild rye operating at pretty, we'll call it with a pretty good high performing reservoir. And we don't see a lot of pressure response to at least what it's approved for now. So I think with each of those injection wells, the availability of data are going to help to guide that. It's hard. It would be hard to say that at this point, our understanding suggests there would be an induced seismicity risk, ultimately, because from what we have been able to do in evaluating the project area, we don't see or interpret any faults at this particular location. Now, that doesn't mean if we get additional data down the road and we see that there are faults in the area, then the assessment of induced seismicity risk is going to have to be updated to kind of characterize that.
Yes, that kind of takes me to my next question is there's no any page reference, but was any 3D seismic data utilized in evaluation and preparation of the FSP model?
At this time, no. The faults interpreted are either based on published faults or mapped faults that we've been able to identify through well control. At this point, the client is still continuing to try and identify if there are 3D available to take the next step and enhance our understanding of the project area.
Well, those are the questions I have for you, Mr. White. Thank you very much.
Thank you.
All right, and so I've instructed the technical examiner to provide a list to Mr. Feldward of additional evidence that he wants at the end of today's hearing. So we'll get to that point. Mr. Feldward, redirect.
Mr. White, looking at this exhibit and the questions you just received from the examiner, does his concerns, will that be in part addressed as you drill this well and then you get data about the lithology of the area that you're actually drilling into?
Yes, that would absolutely help.
Okay. And is it for that reason why does it make sense to you to obtain that data before you determine a bottom hole location for any redundant well?
Yes.
Okay. That's all the questions. Thank you.
Is there any recross on that question, Mr. Burnoff?
No, sir.
Okay. Is there any recross? Was there any further questions on that issue that Mr.
No,
no, those are all right. Maybe this witness be excused?
Yes, sir.
Okay. Thank you, Mr. White. All right. Now, does that conclude your case in chief?
Yes, sir.
Okay, good. Okay, let's deal with the objection to the exhibit marked F. The objection was the timeliness of it and the redundancy of it. And I've researched the rules carefully while I've been listening to the testimony. And while I agree that the rules of evidence in a adjudicatory hearing under 1915-4 do require the pre-hearing statement to be filed at least 4 business days prior, and part of the pre-hearing statement is the list of the exhibits. In this case, this hearing is going to be continued to a date that we're about to decide. So when it comes to timeliness, I don't find that a good ground to keep these exhibits out. On the other hand, there is the redundancy of them. I do agree that to have this many exhibits saying the same thing, which I understand why you are submitting them, but I do agree that it is redundant. So what I'm going to do is I'm going to instruct the applicant to submit one of the documents. You can choose any one of that you want and label it as Exhibit F, and that can be part of your revised hearing packet.
Mr. Hearing Officer.
Yes.
There's an additional problem from our point of view with this exhibit, even in a truncated fashion. The testimony essentially of an absent third party is being introduced to vouch for Lee Midstream. Lee Midstream is saying, look, this is really important and time sensitive, and here's somebody else who can't make it to the hearing or doesn't want to come to the hearing who believes this to be true, and we're going to bolster our application by bringing in other people. I wouldn't have an objection to a witness from Lario or BTA or the company that they choose coming here and saying this. I will then have an opportunity to ask questions of that person, which I think we're entitled to do. If they're saying that there's great urgency, there's a lot of things that we might want to know about efforts that they've made or not made to seek other AGI wells, because there are, of course, other AGI wells that these companies can utilize. And so I think it's inappropriate as a matter of fairness of being able to essentially confront hearsay testimony by having that person here. And if they're not going to be here, then I think the entirety of Exhibit F should be stricken.
Well, Mr. Birnoff, the rules of evidence are not in effect here.
Understood.
In the adjudicatory forum. I have no reason to doubt the authenticity of the letter. Mr. Feldwert is admitting or seeking to admit these Exhibit Fs, not necessarily for what you said, but mainly for the idea that this is a service that we need in the oil patch.
Well, and as a general matter, yes, I think we can all agree that acid gas injection wells are needed by industry. Does this specific well that this specific company seeks to be issued, as they say, on an expedited basis, really deserve that treatment? You know, I think if Coterra or Lario or whoever the declarant ends up being wants to say that, I think that's legitimate, that's appropriate, relevant testimony, but so too is it appropriate and relevant for the land office to be able to ask, what are you doing with gas that you need to dispose of now? Where is that going? If you're claiming that this is urgent, is that because it's more convenient, or is that because you really don't have any other market options? Those are fair questions if this door is going to be opened. And so that's my point, Mr. Hearing Officer.
And I understand your point, and I think there's ways to deal with your point. I'm still ruling that one of these letters can be attached to the revised exhibit packet and marked as supplemental Exhibit F. I understand your objection. I'm overruling your objection. However, Mr. Birnoff, if you want to cross-examine, or if you want to examine any of these witnesses, then I think you can arrange that with Mr. Feldwert. He might be able to have one of these witnesses or letters. I don't know which one of these letters you might choose, Mr. Feldwert, to attach to your revised exhibit packet, but if you could let Mr. Birnoff know which one it is, then we can make arrangements for that witness to appear virtually so that Mr. Birnoff can pose questions to him as he so chooses.
Mr. Examiner, the only thing I'm struggling with here is the state land office in their pre-hearing statement only raised two concerns. They did not suggest, for example, that this was not needed. Okay, they didn't object to the well. They just said, we're unclear about the redundant well, and we want you to pay us for the pore space that you may use at some unknown point in the future. That's all they raised. So I think it's improper for them to now come in and say, well, we don't think, he seems to be saying, and maybe I've heard it wrong, that they seem to be saying, well, we don't think you really need this well. Is that what they're saying? And if so, it's untimely and should not be allowed.
I think Mr. Feldowert, I think it's not something that the state land office would have known about because this was submitted just yesterday, this part of your exhibit packet. This was a revised exhibit packet.
Agreed on this letter, okay? But the point that he seems to be disputing is the need for this well in the area. That is addressed by our witness, Mr. Howfast.
I think he just said a moment ago, everyone can agree that we need acid gas injection wells. He just stated that a few minutes ago when he was making, reasserting his objection, which basically I've already given my decision on this. And I think the idea being that if he wants to ask questions to whoever it is who authored the exhibit that I've already allowed you to admit in your revised exhibit packet, and there needs to be more revisions according to Mr. Gebermichael, that he should be able to ask the questions to that witness. So somehow that needs to be worked out. We need to come up with a new date. Before that, Mr. Gebermichael, would you explain what additional evidence you want?
It's not additional evidence, but based on the response and the applications, OCD would like to make some conditions of approval if we're going to proceed with this one. And then we want to give them some heads up what those conditions are going to be.
Do we need to, so you don't need any revised exhibits?
No.
Okay.
No.
Then why don't we deal with that at the very end of the hearing?
We could do that.
Yes. Okay.
Mr. Examiner, may I suggest something? Can we take a break since it's lunch anyway?
I was gonna call the hearing
and for the purpose
for today,
allowing us to come back and ascertaining whether there's really a need for another hearing.
So you feel like you want to discuss something? Okay, that's right. That's fine.
Where they're coming from, yes.
Mr. Hearing Officer, I would just as soon, I'm happy to have any discussion, although we've been looking for answers from Lee Midstream for a long time and not heard any. I'd be happy to have further discussions with council. However, I would ask that we set a date, and then if that doesn't need to proceed, it doesn't need to proceed, and we would promptly advise you if we're able to resolve everything. But I would selfishly, I would like to not have to come back after lunch if we're done with the meat of this hearing.
And Mr. Feldowert, do you have an objection to just setting a date and then the parties can advise the division?
No, I don't.
Okay, that's the way I prefer to do it instead of having to come downstairs in an hour to hear.
Let me go ahead. I'm sorry.
So we're available. We're available tomorrow. We're available Thursday. We're available. Freya, correct me if I'm wrong, but we're available next week on the 22nd and 23rd as well.
There's an OCC meeting this Thursday. So
thank you.
Room would not be available.
Thank you.
We are already scheduled for status conferences on the 24th, so we'll have a court reporter present then. As for earlier in the week, I'm checking.
And I'm okay to do this if we need to do this virtually to hear this within the next week. I'm okay with that. I don't want to hear it after the 20th. I don't want to come back after the 22nd. So the 22nd for me is the last day to hear the rest of this case. So we can do it. So with that being said, Mr. Burnoff, really, we're talking about your witnesses. What date do you want to bring your witnesses to the hearing?
The best dates for us, Your Honor, Mr. Hearing Officer, are going to be either Monday, the 21st in the morning. I don't know if,
keep going.
Is this a 9 o'clock setting? I mean, I'm assuming that. But
Monday doesn't work, but keep going.
okay, well, so if Monday doesn't work, Tuesday, the 22nd.
Okay.
I didn't hear if Friday is open for you all, but we're all available.
Okay, let's go to Mr. Felderwart. Mr. Felderwart?
Friday works.
Friday works.
Yeah, the 18th.
Okay. I'd like to do that as early as possible on the 18th. Are we talking about coming back to this room or just virtually?
I would prefer to come back to this room.
Okay,
And the
fine.
witnesses here, right here. in
That's
town.
fine.
Will your witnesses be here?
I was hoping that at least one of the witnesses
Fine.
could participate virtually. I'm happy to be here if that makes a difference.
Both of your witnesses can appear either virtually or in person. I'm just asking so that I know what we need to do.
We'll have one witness who needs to, if possible, appear remotely.
And then another one would be here.
Right.
Fine. So 8 a.m. on Friday morning?
Okay.
Okay, Mr. Felderwart, 8 a.m.?
8 o'clock.
Yes, 8 a.m.
Will the room be open by?
It's going to be open. We'll open it early. We'll be here. I get here at 7.
Okay.
So I will be here to welcome you with
Well,
open
I'm not
arms
going to object to that.
on Friday morning.
I hope there's going to be coffee and donuts.
I
or
don't
something.
think so, unless you bring them.
Okay.
There won't be. Mr. Gilbert, Michael, you're okay with 8 a.m. on Friday morning?
No, I'm okay, but I
Okay.
can present those questions on Friday as well if you wish.
Mr. Geber Michael, the correct answer is no, I'm not okay with Friday at 8 a.m.
Too late.
Yeah.
40 still available.
We come early, you know.
Okay. So now, is there anything else, Mr. Felderwart, that you want to accomplish now before we break for the day?
No.
No. I know Ms. Vance would come. Don't worry. I'm not forgetting you, Ms. Vance. Okay, so Mr. Felderwart, we'll see you here at a little before 8 o'clock on Friday morning to continue this hearing.
Sounds good. Thank you for your
Thank you.
time.
And so please decide which of those Exhibit Fs you want to keep in the packet. Do you already know which one?
No, I don't.
Okay.
But do you need me to refile the entire packet or can I just submit a supplemental Exhibit F as just a
Well, the problem
three-page
is that we have 2 exhibit packets in the record as of now. We have the original one from the
Right.
9th. We have the one from the 14th, which has all of the F letters in there.
Right,
We just want to have one letter in there.
right.
So I prefer to have it resubmitted with just the one letter.
The entire package A
Yes,
through F. Okay,
Yes.
all right, got it.
Yes,
Okay,
please. Thank you.
will do.
Thank you. And please, would you mark it second revised exhibit packet?
Yes.
Thank you. Mr. Birnoff, anything else for today?
Nothing else from me. Thank you.
Thank you. We'll see you then. Ms. Vance, let's recall your cases and let's dispose of them.
Thank you.
I'm going to recall case 25388, 25390, 91, and 93. Ms. Vance, we already have your entry. The technical examiner has reviewed the revised exhibit packet. I don't know if your microphone is on or not.
It is. Do you need me to turn it off?
No, it's great.
Okay.
I just didn't see it from here. And he says that we're good to go. We will take these 4 cases under advisement. So we're done.
Thank you.
right.
Greatly appreciated.
You're welcome. So, Ms. Hardy, did you stick around for anything in particular? You're going to lunch with Ms. Vance?
Yeah. No, I was on the same case as
Oh, you on the
Ms.
same
Vance.
case? I didn't know that.
Yes.
Then we're off the record and thank you.
Thank you. Thank you.
Let me know when we have